Article 1521. Whether it is for the buyer to take possession of the goods or of the seller to send them to the buyer is a question depending in each case on the contract, express or implied, between the parties. Apart from any such contract, express or implied or usage to trade to the contrary, the place of delivery is the seller's place of business, if he has one, and if not his residence, but in case of a contract of sale of specific goods which to the knowledge of the parties when the contract or the sale was made were in the some other place, then that place the place of delivery. Where by a contract of sale the seller is bound to send the goods to the buyer, but no time for sending them is fixed. The seller is bound to send them within a reasonable time. Whether the goods at the time of sale are in the possession of a third person, the seller has not fulfilled his obligation to deliver to the buyer unless and until such third person acknowledges to the buyer that he holds the goods on the buyer's behalf. Demand or tender of delivery may be treated as ineffectual unless made at a reasonable hour. What is a reasonable hour is a question of fact. Unless otherwise agreed, the expenses of an incidental to putting the goods into a deliverable state must be borne by the seller. So in this article, when it applies on how to use it, if the ownership has not yet passed to the buyer, but the risk of loss has already shifted to the buyer must still pay the price even if the goods are lost or deteriorate unless the loss or deterioration was due to the seller's fault or negligence. So, for example, the buyer purchases good to be delivered later. Risk passes upon a contract. So, a store destroys the goods before the delivery without seller's fault. Buyer must still pay. So, in this article, it separates the ownership from risk. Normally, risk follows ownership, but sales law allows risk to shift earlier but by agreement, usage of trade, or by any operation of other delivery rules. So it prevents the buyer from avoiding payment when loss happens after risk has shifted, while protecting the buyer if the seller's negligence caused the loss. So, if you asked when does risk shift before ownership, so the answer is in the contract terms. Parties can state risk passes upon shipment or upon tender, while title passes later, like for in the upon a full payment. So the delivery to carrier, it is under the article 1523. Delivery to a carrier generally counts as delivery to the buyer, shifting risk during transit unless the seller failed to make a reasonable shipment or to give notice to the insurer when customary. And the trade usage of billing. If it is customary that buyers bear transit risk, that usage can shift risk even if title is retained. Like for example, the retention of title for the security. The other one is the seller fault or the negligence exception. If loss is due to seller's breach, like poor packaging, unreasonable carrier, or late shipment, failure to notify the insurer when usual or unsafe storage, buyer is not stuck with the loss. If the seller reserved the right of disposal, otherwise kept control, contrary to a normal shipment, risk may remain with the seller unless the contract says otherwise. So the consumer protection may override contract allocation in consumer context. So that's all about the Article 1521. Article 1522. where the seller delivers to the buyer a quantity of goods less than he contracted to sell, the buyer may reject them, but if the buyer accepts or retains the goods delivered, knowing that the seller is not going to perform the contract in full, he must pay for them at the contract rate. If, however, the buyer has used or disposed of the goods delivered before he knows that the seller is not going to perform his contract in full, the buyer shall not be liable for more than the fair value to him of the goods so received. Where the seller delivers to the buyer a quantity of goods larger than he contracted to sell, the buyer may accept the goods included in the contract and reject the rest. If the buyer accepts the whole of the goods so delivered, he must pay for them at the contract rate. Where the seller delivers to the buyer the goods he contracted to sell mixed with goods of a different description not included in the contract, the buyer may accept the goods which are in accordance with the contract and reject the rest. In the preceding two paragraphs, if the subject matter is indivisible, the buyer may reject the whole of the goods. So, in these provisions of this article are subject to any usage of trade special agreement or course of dealing between the parties. In Article 1522, in sale or approval, trial passes only upon acceptance or retention beyond the allowed or reasonable time. Like for example, the buyer takes a machine on approval for 10 days. So he keeps it 20 days without rejection. So the ownership passes at the day 10. Um, so the title passes to the buyer only when the buyer signifies approval or acceptance to the seller or does any act adapting the transactions. The buyer keeps the goods without notice of rejection under if a return period is fixed upon its expiration and if no period is fixed upon expiration of a reasonable time. So in this article, it treats these deals as a conditional. The buyer may try or test the goods first. The ownership stays with the seller until the condition or the acceptance beyond the reasonable time occurs. So that's all about the article 1522.
My assigned articles are 1523 and 1524. Article 1523 states that where in pursuance of a contract of sale, the seller is authorized or required to send the goods to the buyer. Delivery of the goods to a carrier, whether named by the buyer or not, for the purpose of transmission to the buyer is deemed to be a delivery of the goods to the buyer, except in the cases provided for in Article 1503, first, second, and third paragraphs, or unless a contrary intent appears. Unless otherwise authorized by the buyer, the seller must make such contract with the carrier on behalf of the buyer as may be reasonable, having regard to the nature of the goods and other circumstances of the case. If the seller omit so to do and the goods are lost or damaged in course of transit, the buyer may decline to treat the delivery to the carrier as a delivery to himself or may hold the seller responsible in damages. Unless otherwise agreed, where goods are sent by the seller to the buyer, under circumstances in which the seller knows or ought to know that it is usual to ensure, the seller must give such notice to the buyer as may enable him to insure them during their transit. And if the seller fails to do so, the goods shall be deemed to be at his risk during such transit. In Article 1523, when delivery to carrier is delivery to buyer, this article deals with delivery to a carrier on behalf of the buyer. So the general rule, delivery to carrier is delivery to buyer. If it is the duty of the seller to send the goods to the buyer. So there are two kinds of delivery to carrier. Delivery to carrier may be CIF, cost, insurance, and freight. Since the selling price includes insurance and freight, it is understood that said insurance and freight should now be paid by the seller. If OB, free on board, the sale may be number one, if OB at the place of shipment. Here, the buyer must pay the freight. If OB alongside the vessel, here also from the moment the goods are brought alongside the vessel, the buyer must pay the freight or expenses. If OB at the place of destination, here the seller must pay the freight since the contract states if OB board till destination. So we have a problem. S in Manila agrees to ship goods to B at Buwak. If OB Buwak. Before the goods reach Buwak, they are destroyed by a fortuitous event. Who bears the loss? So the question is, who bears the loss? Answer, S bears the loss because ownership does not pass till the goods reach Buwak. Hence, the seller bears the loss. If the price has been given him, he must return the same. If no payment has yet been made, he cannot successfully demand the price from the buyer. In Article 1524, the, the vendor shall not be bound to deliver the thing sold if the bindi has not paid him the price, or if no period for the moment has been fixed in the contract. In Article 1524, when vendor is not bound to deliver, the seller must deliver and the buyer must pay. If the buyer does not pay, the seller is not required to deliver. This is because a sale is a reciprocal contract giving rise to reciprocal obligations. If period is fixed for payment, if a period has been fixed for the payment, the seller must deliver the thing sold even if said period has not yet arrived. He will then have to wait for the end of the period before he can demand the price, except if the buyer has lost the benefit of the term. So we have a problem. Uh, when is the vendor not obliged to make delivery after perfection of the contract of sale? Explain briefly. So the answer is, the vendor is not obliged to make said delivery in the following cases. Letter A, if the bindi has not paid him the price, for after all, the delivery and the payment are reciprocal obligations. Letter B, if no period for the payment has been fixed in the contract, otherwise the vendor might play a futile waiting game. Letter C, even if a period for such payment has been fixed in the contract, if the if the vendor lost the right to make use of the period and still refuses to pay. That would be all of my assigned articles 1523 and 1524 on the law of sales. Thank you.
Hello, we will be discussing the obligations of a vendor, focusing on Articles 1525 and 1526 of the Civil Code of the Philippines. This article pertains to the concept of an unpaid sailor and the rights concerning the goods sold. Understanding this provision is crucial in commercial transactions to protect the rights of sailors. In Article 1525 defines who is considered an unpaid sailor in the context of a sale contract. According to this article, the seller is deemed unpaid when 1. The whole price has not been paid or tendered. Second, a bill of exchange or other negotiable instrument has been received as conditional payment, and the condition on which it was received has been broken due to the dishonor of an instrument or the insolvency of the buyer. This article clarifies the circumstances under which a seller is considered unpaid, which is essential for determining the seller's right and remedies under the law. It is important to note that if a negotiable instrument like a check is given as a payment and it bounces or the buyer becomes insolvent, the seller is still considered unpaid. Simplify these terms, Article 1525 tells us that seller is considered unpaid if haven't received the full payment for the goods. This also applies if the payment has made through a check or similar instrument that couldn't be cleared. This definition is important because it unlocks certain rights for the sailor, which we will discuss later on Article 1526. So, in this article, it specifies the remedies available to an unpaid seller. Even if the ownership of the goods has already been transferred to the buyer, these remedies include 1. Lien on the goods or the right to retain them for the price while in possession. Second, in case of the buyer is insolvency, the right of stopping the goods in transit after parting with possession of them. Third, a right of resale as limited by this title. Fourth, a right to rescind the sale as likewise limited by this title. So, Article 1526 provides the actions an unpaid seller can take protect their interests. If the ownership has transferred to the buyer, if the seller hasn't been paid, they have several options. They can hold on to the goods, stop them from being delivered if the buyer is insolvent, resell the goods, or even cancel the resale. These rights ensure that the seller isn't live without recourse if the buyer fails to fulfill their payment obligation. Now, the case obligation of the vendor has 5. 1. To transfer ownership of the thing sold. 2. To deliver the thing sold. 3. To warrant against eviction and hidden effects. 4. To take care of the thing pending delivery with proper diligence. 5. To pay for the expenses of the deed of sale unless otherwise stipulated. In conclusion, Articles 15, 25, and 26 of the Civil Code are vital in protecting the rights of vendors in sales contract. Article 1525 defines the conditions under which a seller is considered unpaid, while Article 1526 outlines the remedies available to such a seller. This provision ensure fairness and recourse in commercial transaction, safeguarding the interests of those who sell goods on credit under conditional payment terms.
Good day, everyone. Article 1527, when unpaid seller's possessory lien may be exercised. Possessory lien meaning right to hold goods because you possess them until you are paid, or legal right to property until paid. Under Article 1527, an unpaid seller may keep the goods if any of the following occurs. Letter A. Sell without stipulation as to credit. In the absence of any stipulation as to credit, the seller is entitled to the payment of the price at the same time that he transfers the possession of the goods. Accordingly, the seller has always a lien upon goods which he sells until payment or tender of the entire price. Example of this is cash sale. If the transaction is cash basis, the seller has no duty to deliver until fully paid. If the buyer does not pay, seller retains goods. Letter B. Expiration of the term credit. Even where the parties agree upon sale on credit, the seller's right of lien may be exercised. By the nature of a credit sale, the buyer is entitled to possession of the goods without paying the price. But if he fails to exercise his right until the term of credit has expired and the price becomes due, he loses the right which he therefore had. Example, A sells B steel bars on 30-day credit. On the 31st day, B still not paid. B still has not paid. Seller can retain the steel bars. Letter C. Insolvency of the buyer. The insolvency of the buyer is another situation where the lien of the seller in possession is revived, even though the time for payment of the price has not yet arrived. This doctrine is only an application of general principle in the law of contracts that when one party to a bilateral contract is incapacitated from performing his part of the agreement, the other party also is excused from performing. It should be noticed that the insolvency does not dissolve the bargain. It merely revives the seller's lien. The insolvency of the debtor is one of the grounds for loss of right to make use of the period fixed in an obligation. Example, A sells B sand and gravel. Credit terms say payment in 60 days, but after 15 days, B's company collapses financially. Now A can retain the goods even if the 60 days have not yet ended. In summary of this article, talks about what the seller can still do if the buyer does not pay, and gives the seller's possessory lien or the right to retain goods as long as he still holds them and the buyer is in default. Let's proceed to Article 1528. Lien generally not lost by part of the delivery. When part of the goods is delivered, the unpaid seller has lain upon the remainder of the proportion of the price, which is due on accounts of the goods so retained. However, if the delivery of the parts is intended as symbolical delivery of the whole, and therefore a waiver of any right of retention as to the remainder, the lien is lost. This Article 1528 provides three ways the lien is lost. First, delivery to a carrier without reservation. If the seller delivers the goods to a carrier for shipment to the buyer without reserving ownership or possession, he loses the lien. Example, seller ships 500 bags of cement via LBC cargo to the buyer. Lien is lost even if the buyer fails to pay later. Seller cannot stop delivery using lien. Second, buyer lawfully obtains possession. If the buyer takes actual possession, lien disappears. Example, buyer pick up goods from warehouse using an authorized representative. Lien gone. Third, waiver by seller. Seller voluntary waives the lien. Example, seller tells buyer, sige, kuha lang ang butang bisan wala pa ka nakabayad. The right is waived. So that's all. Thank you.
Good morning. Today we are going to discuss a critical junction in the law of sales. The moment control shifts from seller to buyer, and the one narrow exception that protects the seller from a catastrophic loss. For example, you are an unpaid seller. The goods have already left your warehouse. At this moment, your legal possession is becoming precarious. This brings us to Article 1529. So think of Article 1529 as a rule of relinquishment. So it lists the three definitive moments when you, as a seller, lose your lien or your right to physically retain possession of the goods as security for payment. So these are the instances. So first, when you deliver them to a carrier for transmission to the buyer without reserving your right of ownership or possession. So you voluntarily given up direct control of the goods. Second is when the buyer or the buyer's agent lawfully obtains possession. So this means that the transfer is complete. And third is by your own waiver. So you simply give up the right. So the theme here is voluntary or lawful surrender of physical control. So once any of these happens, your primary leverage is gone. So the goods are, for all practical purposes, already in the hands of the buyer. So now in Article 1530, this is not a rule, but this is an extraordinary exception. So what if after you've parted with possession under Article 1529, you discover that the buyer is insolvent? So the law does not leave you entirely without recourse because Article 1530 grants you the right of stoppage in transito. So what is stoppage in transito? Stoppage in transito is to stop the goods while they are in transit. So this is a very specific limited condition So transit means the goods are neither in your possession nor in the buyer's possession. They are in the neutral custody of a carrier. So this right is a legal fiction that suspends the completion of delivery. If you exercise it successfully by notifying the carrier in time, you effectively resume possession. You are placed back in the possession you were in before shipment, as if the transfer of the risk had been paused. So 1529 says you lose your grip when you ship it or they get it. But 1530 replies, but if they become insolvent while the goods are in that vulnerable in between state in the carrier's hands, you may snatch them back. So, stoppage in transito is not a general right for unpaid sellers, but it is a last ditch equitable remedy specifically designed to prevent an insolvent buyer from obtaining goods for which they cannot pay, but is only available during the narrow window after your lien is lost under 1529 and before the buyer's possession is attained.
Article 1531 talks about when are the goods considered in transit. So when goods are considered in transit, first, goods are considered in transit once delivered to a carrier or bailee for transmission to the buyer but not yet received by the buyer or his agent. Second, goods remain in transit even if the buyer rejects them as long as the carrier or bailee still holds them. So I'll give you a scenario. So first scenario, goods are in transit. So why is it important to identify if the goods are still in transit or what is in transit? So let's goods are in transit. Example, A company ships 100 laptops to B company by via XYZ, a common carrier. So uh so while en route during the delivery course, so the goods are considered in transit. So why is it important to identify if the goods are still in transit? Because the seller may stop them. The seller has a right or can exercise a right to stop the delivery. So for example, so the first scenario, the first one here, goods are considered in transit once delivered to a carrier. Anyway, so first scenario, let's say on January 6, the goods are on truck traveling from Cebu to the XYZ Corporation cargo warehouse. So the goods are in transit because they were delivered to the carrier for transmission to the buyer, and the buyer has not taken delivery. If EduHub becomes insolvent on this day, so while during the course of the delivery, the seller may exercise the right of stoppage in transito under this article, and also under Article 1530 as well. So situation 2, buyer rejects the good. When the goods reach Manila, or let's say when the goods reach to the area of the buyer, and let's say the buyer inspects them and claims that there's damage and rejects the shipment. So of course the cargo keeps the goods because the buyer refuses to take them back. So under this article, the good remains in transit after the rejection of the buyer, and the cargo still possesses them as carrier, not as a buyer's bailee. So of course, given the scenario, seller can obviously stop the goods. So now let's talk about when goods are considered no longer in transit. So the right of stoppage in transito exists only for unpaid seller and lasts while the goods are in transit. Goods cease to be in transit in any of the following cases. First case, after delivery to the buyer or his agent. Second one, when the buyer or his agent takes possession before the original destination. Third, when the carrier or bailee acknowledges holding the goods on behalf of the buyer. The next one is when the carrier or bailee wrongfully refuses to deliver the goods to the buyer. Um, okay, so why do we need to understand or to have the knowledge when the goods are considered no longer in transit, so that on the contrary on the contrary of what I have discussed earlier, this one you will know that your right to the seller's right for the stoppage of this delivery is already ceased once the goods are considered no longer in transit. Mm. Okay, so first example here, after delivery to the buyer or his agent, of course, given the scenario, when the buyer accepts the delivery, it's tantamount that, right? It's obviously the goods are no longer in transit. So second example, when the buyer or his agent takes possession before the original destination. Okay, wait, I have an example for that one. Anyway, let's say A corporation sells 100 laptops to B corporation, and then in Cebu, let's say in Cebu, from Manila to Cebu. So let's say XYZ cargo, via XYZ cargo. Because supposedly when the delivery or when the products arrived in the XYZ warehouse, XYZ will deliver it to the shop of, let's say, the buyer B corporation. So if the buyer changes his mind and decided to uh, claim the products by his own through going to the XYZ's warehouse instead of waiting for the XYZ cargo to deliver to his shop, then that's the example of this. So when this happened, goods are considered no longer in transit. The original destination supposed to be B's store, but B decided to get it on his own from the XYZ Cargo's warehouse. So that's an example for that. Okay, the next one here. When the carrier or bailee acknowledges holding the goods of the buyer. Okay, so let's say good arrived at the XYZ warehouse. Then the buyer calls them and tell them to hold the laptop. We'll pick them up tomorrow. Um, the cargo acknowledge it. Okay, sir, we are now holding them for you. So now under this article, goods are no longer in transit because the carrier acknowledged holding them as bailee for the buyer. So they're no longer just a carrier. They're now a bailee for the buyer. So when this happens, seller cannot stop the delivery because it is considered no longer in transit. Next one here, when the carrier or bailee wrongfully refuses to deliver the goods to the buyer. Okay, A sends a truck to claim the goods, and let's say the buyer uh, sends a truck to claim the goods to the warehouse, and then the warehouse house refuses without valid reason. So when this happens, the goods are considered no longer in transit. Okay, so now let's talk about attornment by the bailee. So the seller's right to stop goods in transit ends not only when the goods are delivered to the buyer, but also when the bailee carrier attorns to the buyer. When the carrier first receives goods consigned to the buyer, the carrier acts as the seller's agent to transport the goods. To end the seller's right to stop, the carrier must assume a new role as the buyer's agent, holding the goods for the buyer's account rather than transporting them. Okay, so let's go to the next one. Effects of refusal of carrier to adorn or deliver the goods. First, the carrier cannot increase the seller's right by refusing to deliver the goods or acts as the buyer's agent without a valid reason. Wrongful refusal. If the carrier refuses delivery without a proper reason, this does not give the seller extra rights beyond what the law allows. Next one, right refusal. If the carrier has a valid reason, such as the buyer or buyer's agent is not paying the freight, the seller's right to stop the goods remains valid. Okay, I'll give you another example. Let's say, um, okay, um, a a corporation charters a private truck for the shipment. Oh, this okay. No, no, no. This example is for will be for later. All right, so let's talk about this delivery to a ship, etc. Chartered or owned by buyer. So why do we need to? Okay, so if this scenario happened, like the one that let's say A charters a private truck for the shipment. Like I'm a buyer, and then I chartered private, let's say, truck for the shipment. So that truck, uh, can it be considered as buyer's agent or my buyer or my agent if I'm the buyer, or can we consider it as carrier for hire like normal cargo? So why do we need to identify which is which? Because of course, if we considered it as as the buyer's agent, then the goods are not longer no longer in transit. So on the contrary, if we identify it as carrier for hire, goods are still in transit. So that's the okay, that's what this uh all about. So let's have an example here. Okay, so how can we identify? We can identify it by, all right, so just please read this one first, and then, all right, so now how can we identify the difference between, or how can we identify these two? So we can identify this by looking at the truck, or say the cargo, or uh, the transport that they use, how they represent themselves. So the first scenario, if the truck is acting as buyer's agent, let's say, like their representation of themselves. Then of course, if they represent themselves as buyer's agent, then the goods are not in transit. And if they represent themselves as carrier for hire, then the goods are still in transit. Okay. So and just the representation. The representation of themselves is really important to identify if it acts as transporter or agent of the buyer. So that's the important thing. If they act as a carrier for hire, then the goods are still in transit, then the seller can still exercise the right to stop the delivery in case of there's an insolvency. And of course, if they represent themselves as the agent of the buyer, so the products are considered delivered and the agent lose the right or lose the right for him to stop the delivery. Okay, so there's last part here, effect of partial delivery. Okay, the example for this, A sends 100 laptops again to B. However, P just picked up 20 laptops at the pier, and then the remaining 80 are still with the cargo or with the pier or with the cargo that is located at the pier. So under this article, seller may stop the remaining 80 unless circumstances show the seller intended to give up the possession of the whole shipment. So we can read this. Give me a moment. Wait. Okay, if only part of goods has been delivered, the seller can still stop or claim a lien on the remaining goods. However, if there is an agreement with the buyer to give up all the goods, the seller loses this right. So of course, if only 20 laptops had been picked up, then the remaining of the products, the seller has the right to stop the delivery. Unless there is a stipulation that the buyer agreement, there is an agreement with the buyer to give up all the goods, then the seller loses the right, of course. Okay, so next one here we have, okay, give me a moment. Just a moment, I mean, okay, we have article, okay, thank you. Okay, so article 1532. Okay, Article 1532, procedure for stoppage in transitu and effect of negotiable documents of title, if there is. So ways of exercising to the right to stop. The seller can stop goods in transit in two ways. First, taking actual possession. The seller can physically take back the goods or order them to be delivered to be delivered to himself. However, the seller must pay the carrier's freight and other necessary changes because the carrier may have a lien on the goods for the expenses. So when the seller chooses this way of exercising his right, then he must pay the expenses, the cost of this delivery, the whole thing. So giving notice to the carrier or bailee, the seller can notify the carrier to prevent delivery to the buyer. The notice does not need a special form, but the goods must be clearly described so they can be identified. And of course, if you exercise this right, do it in a reasonable time. All right, next one. Effect of an outstanding bill of lading. If the goods are covered by a negotiable document like a bill of lading, the carrier cannot deliver the goods to the seller unless the document is surrendered. If the document is later negotiated to an innocent buyer, the buyer can claim the goods even if the seller had previously given notice to stop them. The only way to protect seller is to require surrender of the document. So this is okay, this is about if the delivery has a negotiable document. Okay, wait, I'm gonna give you an example for this one. Okay, so if there is a negotiable document of title, like bill of lading, so the carrier cannot release the goods back to the seller. Of course, let's say this scenario, the buyer refuses, or um, the buyer refuses, or the seller wants to exercise his right to stop in transito, to stop the delivery. Okay, so if there's a negotiable document of title like bill of lading, then the carrier cannot release the goods back to the seller unless the seller surrenders the negotiable bill of lading for cancellation. So he needs to surrender, so that, okay, it's their rule. So complication. My buyer is holding the negotiable bill of lading. Let's say, however, let's say the buyer has the negotiable bill of lading and endorse it to a third party, to an innocent party. Let's say from A, buyer to B. Okay, so B decided not to buy it and instead introduced the bill of lading to C. So now, can A reclaim the goods? No, A cannot reclaim the goods until the bill of lading is surrendered. So that's the first example. And also, A cannot reclaim the goods anymore because this article, under the law, the innocent third party, which is C, is protected and is protected. So even if A, the seller, the original seller, didn't didn't get paid because of course C paid B, and B, let's say he didn't pay A. So even that happens, the ownership of C to that product, to those products are valid. And even if A has not yet hasn't yet paid yet. So what is the anyway, let's talk about it later. So okay, so what is the remedy of A if this happens? So the remedy of A is not to go against C, but to go against B, the original, the supposed to be buyer, unjust enrichment, or like collection, maybe collect. Oh wait, I have it here. Yeah, because under this law, A cannot go against C because C is an innocent buyer. So anyway, maybe for this article, for that one, the next the uh anyway, anyway, give me a moment. Okay, so again, if the bill of lading is already in the buyer's hand, then the A cannot stop delivery even if B is insolvent. So the carrier must deliver to the holder of the negotiable instrument. Oh, okay, I remembered. I'll discuss it here na lang. So okay, so let's say there's an innocent third party. So, well, just like I aforementioned, A cannot go against D, so A will go against B because the sale is valid and he didn't get paid. So the action of A, it's for B against B, action for collection, action for collection, unjust enrichment, claim of insolvency proceedings if it's insolvent. So anyway, action for collection. So that's it. So effects of an outstanding bill of lading. Julie, libog ba? Anyway, so again, so if there's a stunning bill of lading, okay, A, the seller, in order to stop this, he needs to surrender the original bill of lading to the carrier. And if the buyer has, there's instances, okay, let's make it clear. There's instances that the bill of that the buyer has already a copy of the bill of lading, or not the copy, but he has the bill of lading, and yet he is insolvent, or yet he cannot pay it, and he introduced it or offered or sell it to to a third party. Then what? Then if that's the case, then the sale is valid between B and C, the third party. So the remedy of A is to go against B, not to go against C, because the law protects the innocent buyer because of the bill of lading, because B has the bill of lading and just um, introduce it to C. So that's why the bill is valid. Of course, he's an innocent buyer. So A will go against B, not C. Go against B, file collection, action for collection, or claim for insolvency proceedings, just enrichment. This is because the negotiable document controls possession and ownership. So that's it for this article. Give me a moment. Let's see if. All right. So that's it. So thank you.